Anybody threaten you or coerce you in any way?
Kind of.
Okay, what do you mean, kinda?
I don't want to go to jail again, Your Honor.
Okay, but did somebody threaten you to plead?
Yeah, with jail time, Your Honor.
Okay, but who did that?
Well, technically, you, Your Honor.
So here's what I'll do. I'll pass it. Go talk to Ann.
Mr. Hampton has entered into agreement with the people, and would like to enter that into the record. Your Honor, is it possible to enter into both today, to address both cases today on the record?
That file is not in the courtroom.
Oh, okay, got it.
But I can believe that they'll be touching faster.
Oh, sorry.
But I don't believe it's.
What? Okay.
Talking about bond. That's
Enter plea in another case
Uh,
that's set for prelim.
Yes, yeah. So case 24F55262, just because of the timing with the mental health treatment court evaluation, that one was set for preliminary examination before the evaluation was complete. And that is currently set for exam.
So over there is Ann, right?
Yes.
You know Ann?
Yes.
Okay. So if you had this, that may work out where we could like get rid of two cases and he could plead. I may or may not do it, but usually just go over and ask Ann. Because you asked me on the record, I'll probably say no, because I don't do the filing, so I don't know where it is.
Understood. Yes. So I will.
So would you like to do that today?
I would like to.
So here's what I'll do. I'll pass it. Go talk to Ann.
Thank you very much, Your Honor.
You're welcome.
Your Honor, sorry. Ashley Bashir on behalf of Mr. Hampton. And in addition to addressing the case directly, we would like to address bond and request that a condition, specifically the home confinement tether, be reconsidered.
Okay, I'll get to that maybe at some point.
Good, thank you. Yeah,
Right now, I'm trying to get these pleas done.
thank you.
So my understanding is he's going to plead to count in case ending in 1596. He's going to plead to count 2.
Yes.
Correct? With count 1 being dismissed. That's going to be a guilty plea. Correct, counsel?
Yes.
All right. Then on the other matter, I have a plea form that indicates that the defendant will be pleading guilty to an added count 2 of attempted resisting and obstructing the 1-year offense. Upon a successful plea to that charge, count 1 of resisting and obstructing would be dismissed. And there is an agreement that the defendant is to go to mental health court. That's the court's full understanding of the agreement.
That's right.
May I have the defendant's sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
State your name.
Brandon Hampton.
Man, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor offenses. Is that correct?
Yes.
All right. The first one in the case ending in 1596 is the charge of aggravated assault. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
Mhm.
Yes?
Yeah.
Okay. You also understand in that case that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yeah.
Okay. And understanding that on that case, do you still wish to plead guilty?
Yes.
All right. On the other case, it says court's understanding you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that?
Yes.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Balbo in the 15th District Court. You understand that?
Why are the judges different, Your Honor?
Why are the judges different? Because these allegedly occurred in two separate places. The case that we were just talking about with Judge Valvo, the offense took place in the city of Ann Arbor. And the other case happened in maybe the city of Ypsilanti yes, in Ypsi City, it looks like. I'm sorry, Ann Arbor Township. Okay, so they occurred in two separate jurisdictions. Okay, that's why you have two separate judges. But what's going to happen, I think this is probably really the crux of your question. You're going to go to mental health court on these, right?
Yeah.
So Judge Valvo is actually in charge of mental health court. So when that case goes over to her, that will be where it is. You'll have to go before Judge Barr. Judge Barr will do the initial part of the sentencing and then place you on probation to be supervised by the mental health court. Follow that? So it's just a little bit of a process. Both cases, it's anticipated, are going to end up in the same spot.
Okay.
Okay. You got that? Any other questions on that?
I guess it's not like possible for the other case just to go to Valvo as well.
It will get there. It just can't go directly that way.
Okay.
Okay.
For sure.
Anything else? Trust me, we do this all the time. It'll get there. So it'll catch right up to it. Okay. All right. Any other questions you have?
Just the one about bond, but
yeah, we'll get to that in a moment. All right. So understanding all of that, you still wish to plead guilty to these charges?
Yeah.
Okay. So to the charge of aggravated assault, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yeah.
All right. You signed an advice of rights form, correct?
Yeah.
Do you have any questions regarding any of those rights?
No.
All right. You see a copy on the podium. Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yeah.
All right. Were you on probation at the time of these offenses?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to these charges?
No.
All right. Anybody threaten you or coerce you in any way?
Kind of.
Okay, what do you mean, kinda?
I don't want to go to jail again, Your Honor.
This is the part where you can literally feel the courtroom shift. Like, everyone went silent. Oh no, he really said that? Claiming the judge is out of line for outlining sentencing options isn't just bizarre, it shows he doesn't understand the basic purpose of a plea hearing. Courts are obligated to make sure the defendant knows exactly what they're risking. That's not intimidation, that's federal procedure. And by framing it as a personal attack, he's not just misreading the moment, he's signaling to the court that he might not be competent to follow through.
Okay, but did somebody threaten you to plead?
Yeah, with jail time, Your Honor.
Okay, but who did that?
Well, technically, you, Your Honor.
Oh,
Mr. Hampton, so
tell you what. Why don't we pass the matter? Maybe you can talk to him and we'll give this another shot today if we're comfortable with it. Otherwise, the court may not be comfortable with it, and we might just blow all of this up and it'll just have to happen another way.
thank you.
But I'll give you a chance to talk.
That was Judge Simpson going full preschool teacher mode. Slow toned, soft delivery, carefully spaced words, all to avoid triggering a meltdown. And honestly, that's not kindness, it's courtroom control. If a judge senses you're unstable or playing dumb, they'll start laying out groundwork to protect the record from appeal. The moment this guy drifts any further from reality, the court's next move might not be sentencing, it might be a psych eval.
We're back on the record in the case of the people versus Hampton. We're in the middle of taking a plea. And So I had stated the terms on the record. And Mr. Hampton, I'm going to ask you a couple questions again. Do anything other than what's been stated here today on the record to get you to plead to these charges?
No,
Has anybody threatened you or coerced you in any way to get you to plead?
no,
You're doing this voluntarily,
yes,
of your own free will,
yes,
and because you believe that you're guilty of these offenses?
yes.
All right. We'll start with case 1596. Paperwork, so. Okay, Mr. Hampton, on the date of August 29, 2024, at Washtenaw Community College in Ann Arbor Township, Washtenaw County, State of Michigan, do you recall what happened on that date regarding a Vladimir, is it Parahorov?
I don't know, Your Honor.
All right, did you get into a fight with somebody?
Oh, I know what happened. I don't know what his name is. It sounded like.
Okay, why don't you tell me what happened then?
Oh, I was trying to take a shower, Your Honor.
Okay, and then what occurred?
When I was in the locker room, he had pushed me up against the wall, hit me in my head, and threw me on the ground. And then broke in my property.
Okay, but before that, did you do anything before that?
No,
Okay.
it wasn't until there were 4 people on top of me and I was fearing for my life that I bit him, Your Honor.
Okay, so here's what I'll do. Counsel, because I can see the way that this plea's going, it's not gonna work. So if you guys want to change, I'm not suggesting if you guys want to change things to a no contest. If you want to do whatever, what I will do is I'm back up at 1. I'll call it back up at 1. I think everybody's still going to be here. So, and give you a chance to talk with him, decide whether or not you want to do no contest, please explain what a no contest, go through all of that with him, and then see if we can get this done.
Thank you very, very much, Your Honor. Appreciate it. Thank you.
This is a prime example for me of no good deed goes unpunished. All right, so we'll call it back up at that point. Quarter past these matters again. All right.
We actually, based on the most recent conversation with my client, I will actually seek to adjourn this case for to further advise my client on the offer.
All right.
For the shortest adjournment possible.
February 13th. Both matters.
Thank you very much, Your Honor.
Both matters? Well, that's true. What are we doing with, well, when is the exam set?
Tuesday.
Yes, so would it, apologies. We can see, I'd be happy to file a stip to adjourn that, the exam or for the other case.
Well, you're gonna need a step on the exam.
Yes.
But I only took it because there was gonna be a plea. When do you want the other one adjourned to?
When is the soonest?
I'll set this, I'll adjourn the
After the
1596. I'll adjourn 1596 to February 6th. The other one is stay on track for a preliminary examination. I understand that people are not going to have the witnesses available, or you need a stipulation to adjourn that out. Okay.
Hey, Judge. Tortural Future Assistant Public Defender on behalf of Mr. Zanzar.
What's up, Mr. Simmons?
Zanzar.
Good
Hello.
afternoon. Happy Halloween, man.
Yes, to you too.
I am good to see you, man.
Good to see
I hope for some good news. It's going to work. It's going to work.
Thank you, Judge.
Please.
I've spoken to my client in the hallway.
Really?
Yes, Judge.
Okay.
He's apparently involved in the LEAD program. He is in that program right now with He said Willie is the supervisor there, and APA Robbins is the contact person there. So we are trying to get some information from them as to how he's doing and his success to see about trying to get this situation resolved. I'd ask for a 2 or 3 week adjournment, please. Is that all that accurate?
Yes, sir.
Wow. Yes, yes, you may. And I know council's got to figure out what's going on with you in the lead program and figure all of that out.
Yes.
If I sent you over for a drug test, are you testing at community corrections?
Yes.
You are?
Yes.
Okay, when's the last time you tested?
Last year.
Last year?
Yeah. If not 2 years ago.
Okay, but you're not currently going over there?
No, not at the moment.
Okay, so let me ask you this.
Yes, sir.
If I sent you over there today, what's that test gonna look like?
I would say negative, meaning good.
Okay, so let me ask you this. Is it gonna come back negative?
Yeah, maybe, I believe so. You know, by the power of God, I believe it's going to be awesome, man. I believe it will be good.
You said maybe it will?
No, maybe not. I believe so.
Maybe not?
I believe so.
Okay, let me ask you this. You been using anything that might show up? Now, hold on before you just out and out answer me. I need you to tell me the truth. Because if you don't, you wanted something good to happen today, but if you don't tell me the truth and something comes back, we're gonna have a problem.
You're not using any drugs or narcotics. You didn't tell me if you are using something. You're better to tell him now. I'm gonna say no, and it come back positive way. So if you are doing something, you should tell him. If you're not, that's fine. But tell him the truth.
Hey, Judge, nope, I am not doing no substances.
Nothing's gonna come back. It's gonna come back all clean.
Yes, sir.
Okay, so can I trust that if I pass this matter, can I trust you to get yourself over to community corrections for me?
Oh, yeah.
You know where it is?
Mhm.
You don't need me to have somebody get you over there?
No.
Because you know how my cab system works, right?
Yeah.
Yeah.
You know me, man.
Okay. All right. So what I'm going to do is I'm going to put this case aside. You get over to community corrections. We're going to have to do a quick order. Get it over to them. And I want you to do a drug test, okay?
Yes, sir.
All right. We'll see. And then you need to come back.
Okay.
Okay?
Okay.
I'm gonna walk him out and point him out to the building.
Yes.
Try to help him make sure he gets there. So you gotta go there now.
Okay.
Take the test, and then come right back. Okay. All right. I'm gonna walk him out now, Judge.
Let's just do it one time.
I'm
Pardon?
gonna walk him out now.
Yes, go for it. Okay. Court does call the case of the people versus Andrew Krupa.
Just both of you on behalf of people.
Good afternoon, Judge. Josh will be on behalf of Mr. Krupar. He's present to my right as well.
Your name, sir?
Andrew Stevens, Krupar.
All right, what are we doing on this today?
Your Honor, we have a couple of things. First is Raymond, if Your Honor is looking to do that on his file, but basically we had a complicated situation where MSP swore to a new case a 15 file yesterday, but it was a valid case. The physical file hasn't made it to this building.
Right.
So I engaged in making a makeshift court file.
Yes.
We will need to and I otherwise understand that we have another matter that needs to be addressed as well.
Yes. Is he, have you seen a copy of the?
I haven't, but we've been in I know that the main charges, but no, I have not yet seen a copy.
He's charged with 8 counts.
Okay.
The most severe, smaller from the. Yes.
We just cleared that today.
Okay, that's why the officer standing behind them because
no
it's still
problem.
showing.
Yep, we cleared it this morning. No problem. Perfect.
All right.
I have, sorry.
Did you wish for me to formally read the complaint to you?
No, Judge, I would waive the formal reading. Thank you. We stand mute and ask that you enter.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea. I don't really have a case number to call off of this yet. I'll call it by the, I even have a report number.
I can give you the form.
You got a case number? Yeah, go ahead.
24F556.
Got it. Got it. Actually, it's on the print. Thank you, Emily. All right. Defendant having waived formal reading, standing mute, court will not enter a not guilty plea. I will set a probable cause hearing in this matter. Defendant demanding same for the November 14th. So where?
Judge, can I
Yes.
interrupt?
Go ahead.
There's a case that's in Macomb. I know that you're about to address as well. That case is also set on November 14th. I'm happy for this one to take priority, but I just wanted to let you know there's also a hearing on that.
Well, I'll set this one then for November 21st,
Thank you.
2024. I don't think this is the right format, but that's okay. I'll take care of it. It's at 9 a.m. Has to bond in this case.
The request be taken into custody and the bond be set at the amount of $150,000 cash surety. The defendant count one is facing up to life in prison for trafficking of over 1,000 or more grams of cocaine. This defendant came into under investigation by Michigan State Police when federal authorities determined that he had been trafficking drugs internationally from Europe as well as interstate many times from California. Engaged in an illegal contract with younger people. He paid them about $100 to $200 per package and said, can I have these packages delivered to your home? And let me know when they're there, I'll come pick them up from your porch. He did this numerous times, further, including at least 10 times from California. The feds then intercepted a package that they determined to have MDMA in it. This then led to a search warrant where the package was successfully under surveillance delivered to the home, and the Michigan State Police, and specifically LawNet, began an investigation into Mr. Krupar. Once the package was delivered to the home, the person who was supposed to notify him that the package was there did so. Mr. Krupar arrived, took the package, and the police attempted to arrest him as well as execute a search warrant on his home. When they executed a separate search warrant on his home, there was a great deal of controlled substances that were recovered, over the 1,000 grams of cocaine. There was separate drugs that were recovered from his vehicle as well. Notably, though, while the penalties, unfortunately, for resisting obstructing the police are just not as substantial, although they should be, when the police attempted to take him into custody, he attempted to flee. He ran from them and he resisted arrest. So not only do we have a person before Your Honor that has been engaged in international drug trafficking, he has, and I will, this is a 2021 case that is not at the fault of MSP. This is a case that once the federal authorities are involved, it takes a very, very long time for it to be processed. As soon as MSP was able to enter this into on-base, they notified me immediately and I was able to bring the charges before Your Honor. This defendant, notably, is also before Your Honor on our other PCC case. Mind you, that case is not as substantial in terms of penalty, but in 2024, which is the case he's otherwise here before Your Honor, he's otherwise in possession of cocaine and just over $9,000 in cash that we understand to be the proceeds of drug trafficking. That's on the other file that's scheduled for PCC today. Similarly, the warrant that I understand defense counsel may indicate to the court has since been cleared perhaps today, but the no bond warrant that was out for his arrest today was for a CSC case in Macomb. He also has another case, I believe it's, I'm going to say it wrong, something about Chippewa. is that the jurisdiction?
Isabella County.
Isabel, thank you. He has another case that came under investigations, frankly, from drug trafficking, but resulted in a malicious destruction of property or some charge along those lines that he's otherwise dealing with. So while this case is from 2021, it's not as if he's had his hands clean since then. Instead, he has picked up numerous other cases in CSE case, and he has also previously been prosecuted for CSE in our county. So, Your Honor, at this time, our request bond is set at $150,000 cash.
I mean,
Yes, sure.
so I'll work my way backwards a little bit here. The charges in Macomb County, he had a failure to appear on a confusion on dates. We went to the Judge Julie Gotti this morning before we came here, Judge. Actually, this afternoon at 1:30, we appeared before her. She set aside the bench warrant. That case, while it appears to be a CSC case on paper, the CSC charges will be dismissed on November 14th, and he'll end up pleading to 1 count of use of analogs. So just so we're clear on that, as far as the case that he picked up here, the 2024 case, obviously we were before this court. He appeared before this court every time. He has a bond on that case that this court gave him. This 2021 case is not something that that he has run from, despite what may have been. I guess I'm not saying any false statements were made by Ms. Hughes at all. I'm saying there was an attorney that was involved earlier on with the forfeiture part of this case, and he has been there and has had that attorney until he's now hired me to address this case when it came up. Knowing this case was coming up, Ms. Hughes was kind enough to tell us last time that she was going to be authorizing the charge. He's still here and showing up for court. He has a tether on his ankle right now, and he shows up for court when he's supposed to be there. That may sound undermined by the fact that they issued a bench warrant in Macomb County. Honestly, Judge, it was a confusion of dates, and we cleared that up today. He's got other matters that are going on in Isabella County that he's resolving, and there have been no issues as far as his failure to appear or anything like that. So at this point, Judge, I understand the nature of the charges. I'm at a bit of a disadvantage factually because I don't have any discovery, nor should I at this stage, I guess. So I'll make sure to get that. But this is 2021, and he's here and been here. I think I know he'll be here again in the future. He's got a tether on so the court can keep an accurate, oversight of him. I have a feeling that the case in Isabella is going to end up resolving with jail time up there, so he's not going anywhere on that one either.
What court is that out of?
That is out of the Isabella County Circuit Court. I'm sorry, I don't know the number, Judge.
Do you know the number?
Maybe third. Oh, you know what?
Does that include Mount Pleasant?
That is Mount Pleasant. Yes.
Got it. 21st. Well, you're saying what's going on with that case?
He's being ready to be sentenced on that case. I know the sentencing date is getting, I think, selected, but he ended up pleading to drug charges up there, which his guidelines.
Well, there's a problem then. Are you handling that case?
Yes.
Because there's a warrant for him on that case.
And all I knew is that when we went to the sentencing last time, the judge was going to hold the warrant until we can get resentencing done on him. So, and that's because of the confusion on the.
Well, when was that?
It wasn't within the past week or two. It was, I think it was the day after we were in court here last time.
Because I've got a warrant date of 10/18/24.
We've been to court since then. I think when we went to court since then, a PSI was issued. And I think that's why, the PSI issued on 10/14. The warrant, there was the warrant for the failure to appear on 10/18. And I think we went back before the court either on 21.
You're saying they didn't cancel the warrant?
I didn't know the warrant had issued. I know the judge initially said he was going to hold the warrant. I didn't know that the warrant had ever actually issued. Maybe it issued.
I've got a warrant for, what do you got?
Which one are you looking at to confirm the Mount Pleasant one?
I've got a warrant that indicates it was issued on October 18th, 2024 out of Mount Pleasant on a charge of destroying evidence. And it says hold with no bond.
Part of the, I know he was charged in one of the charges with tampering with evidence, so it's part of the same case. Why it would only issue on the one charge. I know that I appeared after that and the PSI was being updated, which it did, and we're waiting for the sentencing date, but maybe it didn't get set aside, or I don't want to speak on it because I don't want to say something wrong to the court. My understanding was the judge initially issued a warrant because there was the failure to appear, but he held the warrant without entering.
I don't
Now it's entered,
know.
apparently.
It's entered. It's been entered since the 18th of October and not cleared. And
I understand the ramifications of that, which is why we cleared a different one today. And had I known about it, I would have tried to make sure it got taken care of before today. Unfortunately, didn't know about it.
anything else? I
Um,
mean, I got, part of the problem is when I look at these dates of offenses, I would tend to agree with the people that well, this one's a 2021, his behavior exacerbated itself in a certain respect because got that, and then from 2001, and then the current case that I have, understanding what the people are saying about what he was found with that led to the current charges is extremely troublesome to me. It's also extremely troublesome that the drugs involved in the, if true, that paying young people to transport, in essence, cocaine, methamphetamine, and fentanyl, well, is hugely problematic for me. And then being found later with drugs and a large amount of cash, and then having these other charges where there are warrants and he doesn't seem to deal with what he needs to deal with. So,
and Judge, I agree with everything. Not that you're asking me to agree. I just want to make sure you know, had we known about that other warrant, I would have came into this court, made sure it was taken care of. But I understand completely the court's concern. I know the prosecutor's asking Judge for 150,000 cash surety. The only thing that I would ask is if you could add a 10% provision, tether provision. I'm not even sure you can post that, but if you could.
well,
This is the turning point. The judge is no longer weighing options. He's making a decision based on risk. When a judge uses words like dangerous to the community, that's huge. It means the court believes releasing this person could put others at risk. Add in large amounts of cash, repeated offenses, and allegations of trafficking, and the situation becomes extremely serious. Bail isn't just about showing up to court. It's about public safety. And right now, the judge clearly doesn't feel confident on either front. So what happens next is almost inevitable.
I don't, quite frankly, I understand what the people are asking for. I don't think that's quite frankly a high enough bond. I mean, I think that this individual is a very dangerous individual, sort of spewing poison out there into our communities, at least as it's alleged, and then doesn't seem to learn his lesson and then is caught again. And I have very serious concerns. If he's walking around with $9,000 in cash on this, after he has that I've got a case that at least in terms of some evidence, it's alleged at least that he's destroying. And then there are other charges kind of all over the state of Michigan. This person seems to me to be not only dangerous to the community, but it certainly poses, as the court views it, a flight risk in terms of having the ability to take off. And anything else you want to say before I set bond?
No, Judge, and frankly, looking at the charges and everything that you're looking at, I certainly understand where the court's perspective is from. The only thing I would remind the court is he knew about these things coming and he still has been here. Again, the court I know considers that just a small portion of its consideration. That's all.
If the defendant does post the bond in this case, then he is to be placed back on, if that tether is removed, he's to be placed back on a home confinement tether. If he were to post this bond, I'm going to set his bond. And what are we doing on this case that's before me today?
So until I get the discovery on the new case, Judge, I would ask that it be adjourned together, if that's okay.
I'll adjourn that out to November 21st, 2024 at 9 a.m. or as it indicates. Bond on that matter will continue. Yes, Ms. Hughes.
Can I ask for a no contact order as well? There's one for Catherine Davis. If I can request a no contact order for Catherine Davis.
No contact with Catherine Davis.
And then could I also request a no contact order with Kaylee Aldridge?
Give me a spelling.
AALEIGH Aldridge ALDRIDGE. And then we could have.
And the Catherine is spelled which way?
Catherine is KATHERINE.
And what was the last name? Sorry.
And finally, we could have
Davis was the last name.
Put his current address on the record.
There's been an anticipation with the other case, Judge, that he wouldn't be able to stay any place long because if he's going to be incarcerated, there wasn't really a reason for him to establish a more permanent residency. So that was the only issue. I'm not sure if that's the entirety of it, but I want to make sure the court.
All right. I will let her know contact with Catherine Davis, Kaylee Aldridge. As indicated that if the defendant posts a bond I'm about to set, then he is to be placed on a home confinement GPS tether. And at this point, until I can, I certainly will take a look at it, but looking on the face of this with everything else that's going on and having a no bond hold in Isabella County or Mount Pleasant, the court in this case is going to set his bond at $500,000 cash surety. Defendant is remained.
Understood, Judge. And obviously with that no bond hold anyway, I appreciate it. Thank you for your consideration. And if I need something in writing after I get the discovery, I'd appreciate that. Happy Halloween.
This courtroom session delivers two powerful lessons. In the first case, the judge gave a simple chance. Be honest, take responsibility, and move forward. But even small hesitation can create doubt, and in court, doubt has consequences. In the second case, we saw how repeated behavior, multiple charges, and lack of accountability can build a case far bigger than any single incident. The result? A massive $500,000 cash bond and serious restrictions. The message from the judge is clear. Honesty matters, responsibility matters, and patterns of behavior will always catch up with you. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.